Hello everyone, this is immigration attorney Raluca Hanea and welcome to part 2 in our video series about employer-based immigration. Today I will answer some of our most frequently asked questions about employer-sponsored visas. In our first video, I talked about different types of work visas one can apply for and the steps to obtain them. First question, what does EB stand for? EB stands for employment-based. These initials are used in front of several different types of visas that are granted through employment-based sponsorship. However, there are many visas that are possible to obtain through employment-based sponsorship that do not begin with EB. What types of foreign labor can be sponsored by businesses? Businesses can apply for time-limited visas, such as an H-1B, or a green card, also known as legal permanent residency, for their foreign labor employees. What is employer-sponsored immigration? Employer-sponsored immigration is when a business sponsors a foreign laborer or foreign national as legal permanent resident through a permanent job offer. What is the difference between immigrant and non-immigrant status? Someone with immigrant status is working toward becoming a legal permanent resident and eventually a U.S. citizen. Someone with a non-immigrant status is in the U.S. temporarily and they are not considered to be moving toward becoming a U.S. citizen. Can an employer apply for a green card for foreign workers? Yes, the employer can apply for a green card for their workers, which provides the worker with what is known as lawful permanent status, so they are now legal permanent residents. This is not the most common application for employers, but it can be done. What is the most common application for employers to sponsor someone? As of July 2018, the most common application filed by employers for foreign workers is the H-1B visa. An H-1B visa is a non-immigrant visa for professionals. What is the first step in employment-based immigration? The first step in employment-based immigration, most often, is a company must obtain an approved application for permanent labor certification from the Department of Labor. This is also referred to as a PERM. Once that is obtained, or if it is not necessary, the employer files a Form I-140 for the employee. Is there a limit on how many workers can be granted a visa through their employer's application? Yes. Just as there is a limit on applications for green cards through employment sponsorship, there is a limit on temporary worker visas that are granted yearly. Does an employee who is here on a temporary visa or legal permanent resident need to get an employment authorization document? Yes. After coming to the United States, a worker must obtain an EAD, which stands for Employment Authorization Document, whether they are here temporarily or applying for legal permanent status. Is there a limit on how many workers can be granted a green card through their employer's application? Yes, there is a limit. The U.S. Department of State is the agency that determines the immigrant visa numbers. Employment-based immigrant visas are limited to 140,000 a year as of today. There are also limits on the percentage of immigrant visas that are allotted to each country. And with this last question, we conclude our video today. As usual, we appreciate your likes, shares, and your questions. We are here to help. And thank you for watching and see you next time.